And no valid driver's license. You understand the charges?
You understand what you're charged with?
No?
No.
No. She doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license. Yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. I mean, this county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it. Yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it?
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the contract.
Nobody's asking you to admit to anything. I just need to make sure you understand the charge.
I'm a private citizen, sir.
I'm shocked
Under
you're
UCC bubbles.
Oh, UCC? Oh, I love it. A sovereign.
What you're about to see today is a courtroom compilation that perfectly captures the clash between legal authority and so-called sovereign citizen logic. And let's be honest, it never ends well for them. Across multiple courtrooms, different judges are faced with individuals who refuse to accept basic legal procedures, question jurisdiction, and attempt to derail proceedings with pseudo-legal arguments that have been repeatedly dismissed by courts across the country. But what makes today's cases especially interesting is not just the arguments themselves, it's the judges' reactions. From patient explanations to outright frustration, you'll see the full spectrum of judicial patience being tested. And yes, we even have a familiar face, Eric Martin, whose courtroom behavior has already made him something of a recurring character in these kinds of breakdowns. Stick around, because what starts as confusion quickly escalates into contempt warnings, rulings, and some brutally direct courtroom reality checks. And trust me, some of these judges are
500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with two N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal.
Dive deeper into the chaos. This is that moment in almost every long-form courtroom breakdown where the tone briefly shifts, from legal tension to sponsorship. And while it might feel like a pause in the action, it actually serves as a reset before things get even more intense. Because once we step away from the sponsor segment, we're heading straight into real courtroom proceedings where defendants are facing drug charges, licensing issues, and procedural misunderstandings that quickly spiral out of control. So take this moment as a breather, because the next sequences are where the legal friction really begins. We're going from product ads and travel talk straight into Florida courtrooms. And trust me,
The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much
So-
are the bonds? Who
Mr.
issued them?
Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So,
So then what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're
going
not
to have you
responding to any
come.
of my, I don't have a problem of answering any of your questions, but I have a couple questions first. I have to
Miss-
understand too. I don't understand what's going on.
Date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes, good morning, Judge Donna Sub on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements here, talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me, so.
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything you keep doing. All your little negative comments, things that you want to say about people, and you think you're the smartest person.
The judge's insistence on clarity versus the defendant's complete inability or refusal to engage with simple legal questions. The judge isn't trying to trick anyone here. He's literally asking yes or no questions to establish whether the defendant understands the charges. But instead of a direct response, we get hesitation, deflection, and attempts to reframe the situation. This is where the sovereign-citizen dynamic becomes especially visible. The belief that acknowledging the court's framing somehow grants it legitimacy they don't want to accept. But in reality, the court doesn't need agreement. It only needs understanding of procedure. And that disconnect is exactly what causes frustration to build on both sides, leading to delayed
commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I don't want to state also that if it was recorded, that we say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another pointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
Well, I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did. Well, I won't say for the most part. Maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
Yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date.
They collide in a very sharp way. The judge isn't just delivering rulings, he's actively cutting through nonsense with blunt, almost sarcastic clarity. When courts start using phrases like this, it usually signals that patience has already run out and the focus has shifted from explanation to conclusion. What makes it even more striking is how sovereign citizen arguments tend to rely on symbolic or misunderstood legal jargon, but judges operate strictly on enforceable law and procedure. So when those two worlds collide, the result is often frustration, humor, and very direct language meant to reground the proceedings in reality. At this point, the courtroom stops being a place for debate.
First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound.
Courtroom segment highlights a different pattern: outright rejection of participation. Instead of engaging with the court's questions, the defendant challenges the legitimacy of the process itself, refusing to acknowledge consent, jurisdiction, or even basic identification procedures. And yet, despite all of that, the court continues forward as required by law. What's important to understand here is that consent is not required for legal proceedings to occur. The court's authority is procedural, not optional. So, while the defendant frames everything as a matter of personal agreement, the judge is operating within a system that doesn't pause just because someone disagrees with it. That disconnect is what leads directly to escalation, scheduling enforcement, and the looming possibility of...
I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some other
Yes,
thing?
sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you don't have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning
really escalate emotionally inside the courtroom. Eric Martin's repeated interruptions and accusations toward his own attorney create a breakdown in communication that the judge simply cannot allow to continue. At this stage, the issue is no longer just legal. It becomes about courtroom control and respect for procedure. When a judge warns about contempt, it's not symbolic. It's a direct indication that behavior is interfering with the administration of justice. And what's striking here is how quickly the tone shifts from discussion of legal representation to strict courtroom discipline. The judge is making it absolutely clear. Disagreements with counsel are not handled through public outbursts, but through proper legal channels.
Not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So,
okay, so
that is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
U.S. 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was Shuttle.
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it says no license.
U.S. 147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So, for instance, when you said 769 Fed 2nd, 1344, What that means is volume 769 of a book or volumes called The Federal Reporter, second edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case, and what issue was before the Supreme Court in that case?
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't tell me what, that's not a complete cite of the case.
All right. Do you not have the